Yeah, my Divas Jive, that's the name of the song, performed by Hello April. 80 minutes after 3 o'clock. Welcome on the second lap of the program. You're still hanging out with Basi, of course, up until 4 o'clock. It's Tuesday, today the 4th of September 2012. The last hour, of course, we spoke to Edmund Foley, he's with the Child Rights Project, and also we heard from the Rep Ken, just basically looking at the corporal punishment and also related to the child's rights. Joining me now in the studio, I've got the pleasure of being joined by Hajiera Davids. She's with the NADCA, which is an acronym for National Alliance for the Development of Community Advice Officers, as it is the legal practice bill excludes the paralegals and the CACs. Anyway, join us also on 021 448 6266. Hajiera, welcome. Thank you for your time.
Thank you.
It's a great pleasure. The National Alliance for the Development of Advice Officers. Who's this? How it came about?
Okay, basically the context is there are community advice officers situated throughout the 9 provinces. And basically we were fragmented. And this group of activists and people got together and realized we have one common goal, but because we're fragmented, we need to develop ourselves. And that is where the idea of the National Alliance on the Development of Community Advice Officers started. This was formed in 2005, but there's also a separate entity to that, because in community advice officers, we have community-based paralegals who does the legal aspect of work. We are non-profit organizations and we operate in communities, the vulnerable, endangered, and in particular rural areas where people's rights are affected and the administration to justice is difficult to obtain. So this is where we have been operating. Some offices for the Western Cape, I can say, and the one particular office that I come from, we've been operating since November of 1982, which would make us basically 30 years old. And at that time, there were buzzes after the democracy in terms of the recognition of advice officers and community-based paralegals. And one of those things that I would like to put a historical context into that with regard to advice officers and government at that time. What basically occurred was that the late Minister Dalla Umar had his report on transformation of justice system. And in the report he identified 7 key result areas under the access to justice key area. He further identified as formal structuring of paralegals. The late Minister Umar had many overtures to the community-based paralegal sector with the intention of ensuring that they were included in a legal practice bill. Now, this is in 1998. Okay, Minister Dalla Umar, in his discussions and requests to the Swedish government and the Swedish International Development Agency, the acronym being SIDA, made specific reference for the need to support these advice officers and to build on their past work and existing direct relationship with and access to communities. Now, support to the paralegal movement thus became one of the objectives and focal areas of the Swedish government's access to justice programs in South Africa. Now, in 2001, the former Minister of Justice, Dr. Peniel Maduna, set up a task team chaired by Jeff Budleder to draft the legal practice bill. Okay. Now, given the significant differences of opinion by both the attorneys and the advocates profession, 2 bills were drafted, one by the Law Society of South Africa and the other by the remainder of the task team stakeholders. Now, in the chairman's report of April 2002, this is a year later to the minister, Jeff Budleder states that there was consensus between the 2 professions and that, this is very important, the council should be under a legal obligation to promote and support the development of paralegal work in order to promote access to justice. This should be a special committee of the council to promote the development and empowerment of paralegals. Right. So December 2007, this is about 5 years along the line, the Legal Service Charter I will refer to it as the charter here, after was adopted. Now, one of the pillars of the charter is access to justice, and community-based paralegals are recognized as core to this. The charter defines what a CBP is, that is a community-based paralegal, and makes provision for the appointment of a paralegal to the Charter Council by a recognized paralegal regulatory body. One of the objects of the charter would be to devising and implementing measures to address the provision and availability of pro bono services, the emphasis being on pro bono services, and community-based paralegals, thus ensuring access to affordable legal services for all people in South Africa, particularly marginalized, poor and rural communities.
Okay.
In addition to that, the Charter stated it seeks to ensure the provision of legal services in an environment that is conducive to effective access to justice. Okay? Mentions also the pro bono, who the stakeholders would be, for example, community-based paralegal services, justice centers, advice offices, university law clinics, etc. Right.
Okay.
The Charter then on went to say the provide for the regulation of non-commercial community-based paralegal practitioners, that would be us, so as to provide access to primary legal services in rural, poor and marginalized communities. Then we move on to August 2009. This is 2 years later down the line. The Department of Justice and Constitutional Development published the first working draft of the new legal practice bill. The bill appeared to be very progressive and showed a clear intent to integrate paralegals into the formal justice sector. We were very happy about this, and regulate them accordingly. Chapter 2 of the working draft provided for inclusion of paralegals to be represented on the Legal Practice Council. Chapter 3 of the working draft provided for the regulation of paralegal practitioners, and Chapter 4 of the work draft provided for rendering of services and all that I've mentioned before. And then there would be powers and functions of a paralegal committee. Okay, this is also what the council must, what it says must, in consultation with the minister and the paralegal committee, within a period of 12 months after its establishment, submit to the minister legislative proposals to regulate the rendering of legal services by paralegal practitioners, and the minister must, within 3 months after receipt of the proposal, refer to its subsection 1, introduce legislation into Parliament to regulate the rendering of legal services by paralegal practitioners. Then there were ongoing discussions between NatKO, the National Task Team, which represents community-based paralegals, and then the Directorate of Constitution Development of the Department. This is Constitutional Development and so on, and the recognition of work of advice officer and community-based paralegals and their long-term investment, etc., etc. And all this was outlined, and things look positive because we have 230 community advice officers situated all throughout South Africa. Many have accreditation.
Okay.
They've done these courses. They are accredited paralegals, etc. And then, for example, there are 500 community-based paralegals working in 230 community advice offices.
Throughout South Africa.
Yeah, throughout South Africa. Some of them are poorly paid, and others, of course, are volunteers. All right? So, this is how it went, and we waited with bated breath for things to get much better for us. Then on the 15th of April 2010, discussions was again held between the parties that I've mentioned previously. And what we then discovered was that the department had decided to separate paralegals from the legal practice bill and have a separate regulatory framework for paralegals. Now, that would impact negatively upon communities per se, because we would be far removed from the legal system. Okay? And basically, in many instances, our hands as paralegals would be tied. And also, we won't have representation on the Legal Practice Council. So there will be no voice for us in that matter. It will only be governed between advocates and attorneys.
Doesn't it make sense? Because there's people who are dealing with it, they know the expertise of this. They're dealing with something and then taking... I'm not trying to say, Hajiera, of course, the communities don't have, but now we're talking about people who who are experts in the legal system say, okay, yes, we acknowledge you. We know you are around you. Yeah, we're working with you. But now we also need our space as experts. I don't know. Break it down for me, Hajiera. Why you
Yes.
say you see your hands would be now?
Look, this is work we've been doing, and I would like to say many of us are trained and qualified. And then also it's the issue of recognition of early, prior learning. Okay? We draw up wills. We deal with a lot of legal matters in terms of consumerism, the National Credit Act, the laws and all of that, default judgments, etc., etc.
That would be my next question. Well, it seems like now you... I'm not laughing at this. I invited you so that you can explain.
Sure.
It seems like the other one is taking another one's job here.
Well, we have been doing that all the time and without charging people.
Okay.
So maybe that might be a problem that people foresee. But our mandate and our brief is clear in terms of that. We do not charge people for our services. It's a pro bono. You might argue the fact that in terms of pro bono, you could apply for pro bono. Yes, you could. But taken that you go to the Cape Law Society and you apply for pro bono status, they in turn then would have to now write to attorneys or find attorneys that would do. There are matters of urgency as well for community. And at times, you can't wait until people find a pro bono lawyer for you.
Okay.
And with us having that access, if we are included in the bill, is that we could go to court and do that ourselves.
Okay.
For people, we come from communities where we understand.
You know this community.
Precisely. We live there in terms of evictions and all of those. And I'm saying this with all respect to the legal fraternity. In the issues of housing, in particular, if we refer to the municipality, we know what is happening there. It's just not a matter of the law. There are other circumstances that would be taken into consideration in those matters. And that is where we differ from that fraternity, because for them it's just an issue of laws, it's rules, it's regulation. They will refer to subsection here and that. Yes, all of that is relevant, but you need that little extra where you understand where this person is coming from.
Yeah.
You understand? And that is where we have
social issues.
There we go.
The bread and butter issues.
Absolutely. And that always is also not always taken into consideration. Even the presiding officer at times comes from a total different domain. You understand? And if people, for example, would go to an attorney, they don't always see, like you would have an attorney maybe coming from Plattekloof, but doesn't understand the dynamics of the townships. You understand? So what he's going to plead there is just for what he sees in terms of law. But if you can
open that big book.
There we go. But if you speak from the community's perspective, and also, of course, include the law is very relevant, yes. But then, as I say, the rules of law is there. But then our constitution is a much higher body in terms of Section 34, which actually guarantees our rights. And sometimes that is overlooked by courts, and I'm saying that, and I know what I'm talking about.
So we need to look at our justice system.
Absolutely, at times. Because
would you say if the late Dala Omar was around, would he say he would be happy? What would he say?
Yes, definitely. Look, he was a man at grassroots level. He worked at grassroots level. And myself, I had a lot of involvement in terms of our advice office at that section. He and Judge Issa Musa. He was at one time a management committee member. So they are people from the ground at grassroots that knows what was happening there. And I'm sure by now this legal practice bill, as with regard to paralegals, would have been a different matter. You understand? So for me, the issue of the pro bono, because we don't charge for our services, I on occasion have gone where we got the leeway where the magistrate actually allowed us to talk. And we won the case in court. That was one amongst others. It all depends who the presiding officer is today and in what mood they are. You understand? But I do not think the attorney would have done a better job. You understand? In those circumstances, we're saying, what I'm saying, no one should feel threatened about paralegals. Obviously, we don't have those degrees as such, but we have accreditation because we spend years also